Question 1. Compliance review shows that a real estate brokerage in British Columbia is exploring the use of data analytics to optimize its internal processes and decision-making. Which of the following strategies best aligns with regulatory requirements and ethical best practices for data utilization in real estate services? Option A. Utilizing detailed client transaction histories and personal information to build predictive models for identifying individual clients likely to sell or buy in the near future, enabling highly personalized and proactive marketing outreach. Option B. Implementing data analytics to track and improve internal metrics such as lead response times, marketing campaign ROI, and agent productivity, ensuring all client-identifiable data is anonymized or aggregated for analysis. Option C. Analyzing aggregated demographic data from past sales to identify specific neighborhoods with a high concentration of certain ethnic or income groups, and then developing targeted marketing strategies to focus recruitment efforts in those areas. Option D. Employing comprehensive tracking of all agent-client communications and interactions, using the data to create performance scorecards that directly influence agent compensation and client assignment, without explicit client consent for such detailed monitoring. The correct answer is B. Implementing data analytics to track and improve internal metrics such as lead response times, marketing campaign ROI, and agent productivity, ensuring all client-identifiable data is anonymized or aggregated for analysis. Explanation. This scenario is professionally challenging because it requires a real estate brokerage in British Columbia to balance the efficient use of data analytics for process optimization with its fundamental obligations under the Real Estate Services Act, RESA, and its associated regulations, particularly concerning client confidentiality and the responsible use of information. The brokerage must ensure that any data-driven improvements do not inadvertently compromise the privacy of clients or lead to discriminatory practices, which are serious ethical and regulatory concerns. The best approach involves a systematic and transparent implementation of data analytics focused on internal operational efficiencies, such as lead conversion rates, marketing campaign effectiveness, and transaction timelines, while ensuring all data is anonymized or aggregated to protect client privacy. This aligns with the principles of responsible data handling and the duty of care owed to clients. By focusing on these internal metrics, the brokerage can leverage data to improve its services and decision-making without infringing on client confidentiality or engaging in practices that could be perceived as unfair or discriminatory, thereby adhering to RESA requirements for professional conduct and consumer protection. An approach that prioritizes using client-specific data to predict future client behavior for targeted marketing without explicit consent or clear anonymization fails to uphold the privacy expectations and rights of individuals. This could contravene principles of data protection and fair dealing, potentially leading to breaches of RESA ethical standards. Another approach that involves analyzing market trends based on aggregated sales data to identify underserved demographics for the purpose of proactive outreach, without a robust framework to prevent potential redlining or discriminatory targeting, poses significant ethical and regulatory risks. Such practices could inadvertently lead to differential treatment of clients based on protected characteristics, which is contrary to fair housing principles and the spirit of RESA. Furthermore, an approach that focuses solely on maximizing agent performance through granular tracking of client interactions, without a clear policy on data retention, security, and purpose limitation risks violating privacy regulations and ethical obligations. The responsible use of data requires clear guidelines on how information is collected, stored, used, and eventually disposed of. Professionals should adopt a decision-making process that begins with identifying the specific business objective. Then, they should evaluate potential data analytics approaches against regulatory requirements, RESA, Personal Information Protection Act of British Columbia, ethical guidelines, and potential impacts on client trust and privacy. A risk assessment should be conducted for each approach, prioritizing those that enhance operational efficiency while rigorously safeguarding client data and avoiding any semblance of discriminatory practice. Transparency with clients about data usage, where appropriate and legally permissible, is also a key component of responsible decision-making. Question 2. In British Columbia, a real estate licensee is contacted by a former client who is looking to purchase a property. Simultaneously, the licensee is actively marketing a listing for another client who wishes to sell their home. If the licensee were to facilitate a transaction where their former client purchases the property listed by their current client, what is the most appropriate and legally compliant course of action for the licensee to take to manage this potential agency relationship? Option A. Proceed with the transaction, assuming that both parties are aware of the licensee's existing relationships and will understand that the licensee is acting in a dual agency capacity without requiring explicit written consent. Option B. Inform only the seller of the situation, as they are the current client, and proceed with the transaction, believing the buyer, as a former client, will be adequately represented by their prior experience with the licensee. Option C. Immediately disclose the potential dual agency situation in writing to both the seller and the prospective buyer, clearly outlining the implications and obtaining their explicit written informed consent before proceeding with any further actions related to the transaction. Option D. Advise the buyer to seek independent representation and withdraw from representing either party in this specific transaction to avoid any appearance of impropriety, even if written consent could be obtained. The correct answer is C. Immediately disclose the potential dual agency situation in writing to both the seller and the prospective buyer, clearly outlining the implications and obtaining their explicit written informed consent before proceeding with any further actions related to the transaction. Explanation. This scenario presents a professional challenge due to the inherent conflict of interest that arises when a real estate licensee attempts to represent both the seller and the buyer in the same transaction. Navigating this situation requires a deep understanding of the Real Estate Services Act, RESA, and the rules of the Real Estate Services Act in British Columbia, as well as the ethical obligations of a licensee. The primary challenge lies in ensuring that the fiduciary duties owed to each party are not compromised, and that informed consent is obtained transparently and without coercion. The best professional approach involves recognizing the inherent conflict and prioritizing the protection of all parties' interests through strict adherence to disclosure and consent requirements. This means clearly identifying the dual agency situation, explaining its implications to both the seller and the buyer, and obtaining their explicit, informed written consent before proceeding. This approach aligns with the principles of RESA, which mandates that licensees must act with honesty and integrity and disclose any potential conflicts of interest. Specifically, Section 42 of RESA and related rules require licensees to disclose to all parties in a trade in real estate any relationship the licensee has with any other party to the trade. Obtaining written consent after full disclosure is paramount to avoiding breaches of fiduciary duty and regulatory violations. An incorrect approach would be to attempt to represent both parties without fully disclosing the dual agency and obtaining written consent. This failure to disclose is a direct contravention of Section 42 of RESA and the rules, which are designed to prevent situations where a licensee's loyalty could be divided. Such an action compromises the fiduciary duty owed to both the seller and the buyer, as the licensee cannot simultaneously advocate for the best interests of both parties in negotiations. Another incorrect approach is to proceed with the transaction assuming that the parties are aware of the dual agency or that their verbal agreement is sufficient. This overlooks the explicit requirement for written consent under RESA and the rules, leaving the licensee vulnerable to accusations of misrepresentation and breach of duty. Finally, attempting to downplay the implications of dual agency to secure the transaction is also professionally unacceptable. This undermines the principle of informed consent and demonstrates a lack of integrity, potentially leading to significant legal and disciplinary consequences. The professional decision-making process for similar situations should begin with an immediate identification of any potential conflict of interest. This involves a thorough review of the proposed transaction and the relationships involved. If a dual agency situation is identified, the licensee must then consult the relevant provisions of RESA and the rules to understand their obligations. The next critical step is to provide full and frank disclosure to all parties involved, clearly explaining the nature of the dual agency, the potential conflicts, and the implications for representation. This disclosure must be in writing. Following disclosure, the licensee must obtain explicit, informed written consent from all parties before proceeding with any actions that would constitute dual agency. If informed consent cannot be obtained, or if the licensee believes they cannot effectively represent both parties without compromising their duties, they must decline to act as a dual agent and recommend that each party seek independent representation. Question 3. The review process indicates that a real estate brokerage in Vancouver, British Columbia, is experiencing a noticeable slowdown in sales volume, coinciding with a period of rising interest rates and increasing housing inventory. What is the most prudent and ethically sound course of action for the brokerage managing broker? Option A. Focus solely on aggressive price reductions for all listed properties, regardless of individual property marketability or underlying economic factors, to stimulate immediate sales. Option B. Proactively analyze current and projected economic indicators specific to the British Columbia real estate market, such as interest rate trends, employment figures, and local development plans, and use this analysis to inform client advice and adjust the brokerage's marketing and sales strategies. Option C. Continue with existing marketing and sales strategies, assuming the slowdown is a temporary market fluctuation and that traditional methods will eventually yield results. Option D. Advise clients to wait indefinitely for interest rates to decrease significantly before considering any real estate transactions, without providing alternative strategies or market insights. The correct answer is B. Proactively analyze current and projected economic indicators specific to the British Columbia real estate market, such as interest rate trends, employment figures, and local development plans, and use this analysis to inform client advice and adjust the brokerage's marketing and sales strategies. Explanation. The review process indicates a need to assess how economic factors influence real estate markets in British Columbia and how a real estate professional should respond to such influences. This scenario is professionally challenging because it requires a broker to not only understand broad economic trends, but also to translate those trends into actionable advice for clients and to adapt their business strategies accordingly, all while adhering to the Real Estate Services Act (RESA) and its associated rules. Misinterpreting economic signals or failing to act ethically in response can lead to significant client dissatisfaction, financial loss, and regulatory repercussions. The best professional approach involves proactively analyzing current and projected economic indicators relevant to the British Columbia real estate market, such as interest rate trends, employment figures, population growth, and local development plans. This analysis should then be used to inform client advice regarding market timing, pricing strategies, and investment decisions. Furthermore, the broker should use this information to adjust their own marketing and sales strategies to align with prevailing market conditions. This approach is correct because it demonstrates due diligence, upholds the fiduciary duty owed to clients by providing informed guidance, and aligns with the ethical obligations under RESA to act with integrity and competence. It ensures that advice is grounded in objective market realities, not speculation or personal bias. An incorrect approach would be to ignore or downplay the impact of significant economic shifts, such as rising interest rates, on property values and buyer affordability. This failure to acknowledge and advise clients on material market changes constitutes a breach of the duty of care and could lead to clients making ill-advised decisions, potentially resulting in financial harm. Such inaction also violates the spirit of RESA, which mandates that licensees act in the best interests of their clients. Another incorrect approach is to overemphasize speculative economic forecasts without grounding them in current market data or client-specific circumstances. While understanding future trends is important, basing advice solely on optimistic but unverified projections, especially when contrary data exists, can be misleading. This can lead to clients overpaying for properties or making investment decisions that are not financially sound, thereby failing to meet the standard of care expected under RESA. A further incorrect approach involves manipulating or selectively presenting economic information to suit a particular transaction or personal gain. For instance, highlighting only positive economic news while omitting negative indicators to encourage a quick sale would be a serious ethical violation and a breach of RESA. This misrepresentation erodes trust and directly contravenes the requirement to act honestly and with integrity. Professionals should employ a decision-making process that begins with continuous monitoring of relevant economic data for British Columbia. This data should be critically evaluated for its potential impact on different market segments. Client-specific goals and risk tolerance must then be assessed. Advice should be tailored, transparent, and supported by objective analysis, always prioritizing the client's best interests and adhering strictly to the ethical and legal obligations under RISA and its rules. Question 4. Performance analysis shows that the British Columbia real estate market is exhibiting characteristics of a mature phase within its current cycle. Considering this market context, which of the following approaches best guides a real estate licensee in advising a client who is considering a significant property investment? Option A. Focus solely on recent short-term price movements in the local area, disregarding the broader real estate cycle trends in British Columbia. Option B. Recommend a specific investment strategy, such as purchasing a particular type of property, without a thorough discussion of the current market cycle's impact on that strategy. Option C. Advise the client to proceed with the investment immediately, based on personal optimism that the market will continue to appreciate regardless of the current cycle stage. Option D. Conduct a detailed analysis of current and historical market data specific to British Columbia, incorporating economic indicators and inventory levels, to inform the client about the implications of the mature market phase and potential risks and rewards. The correct answer is D. Conduct a detailed analysis of current and historical market data specific to British Columbia, incorporating economic indicators and inventory levels, to inform the client about the implications of the mature market phase and potential risks and rewards. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate licensee in British Columbia because it requires navigating the complexities of market cycles and their impact on client advice. Misinterpreting or miscommunicating market trends can lead to poor investment decisions for clients, potentially resulting in financial losses and damage to the licensee's reputation and professional standing. The challenge lies in providing accurate, objective, and timely advice that aligns with the client's best interests, while also adhering to regulatory obligations. Correct approach analysis. The best professional practice involves a comprehensive analysis of current and historical market data specific to the British Columbia real estate market, considering factors like interest rates, economic indicators, population growth, and inventory levels. This approach is correct because it directly addresses the licensee's duty under the Real Estate Services Act (RESA) and the rules of the Real Estate Council of British Columbia to act with integrity, competence, and in the best interests of the client. Providing data-driven insights, acknowledging uncertainties, and discussing potential risks and rewards based on the observed market cycle stage ensures informed decision-making for the client. This aligns with the ethical obligation to provide competent service and avoid misrepresentation. Incorrect approaches analysis. Advising a client solely based on anecdotal evidence or personal optimism about future market appreciation, without substantiating it with objective data, is professionally unacceptable. This approach fails to meet the standard of competence required by RISA and the rules, as it relies on speculation rather than informed analysis. It also risks misrepresentation if the optimism is not grounded in reality. Recommending a specific course of action, such as an immediate purchase or sale, without thoroughly discussing the current market cycle stage and its implications for the client's specific goals and risk tolerance, is also professionally unsound. This approach bypasses the crucial step of educating the client about market dynamics and their potential impact, potentially leading to a decision that is not in their best interest. This could be seen as a breach of the duty to act in the client's best interest. Focusing exclusively on short-term market fluctuations without considering the broader real estate cycle in British Columbia is an incomplete analysis. While short-term trends are relevant, understanding the longer-term cycle provides a more robust context for advising clients on significant investment decisions. This limited perspective may lead to advice that is not strategically aligned with the client's long-term objectives. Professional reasoning. Professionals in British Columbia should adopt a data-driven and client-centric approach. This involves 1. Understanding the client's objectives, financial situation, and risk tolerance. 2. Conducting thorough research on the British Columbia real estate market, including historical data, current trends, and economic forecasts. 3. Analyzing the current stage of the real estate cycle and its potential implications. 4. Communicating findings clearly and objectively to the client, outlining potential opportunities, risks, and uncertainties. 5. Recommending a range of options and facilitating informed decision-making, rather than dictating a specific action. 6. Continuously updating knowledge on market conditions and regulatory requirements. Question 5. The risk matrix shows a potential discrepancy regarding a detached garage on a property listed for sale in British Columbia. The seller has verbally indicated their intention to remove the garage after the sale, despite its apparent permanent construction and integration with the property. As the listing agent, what is the most appropriate course of action to ensure regulatory compliance and professional conduct? Option A. Advise the seller to leave the garage on the property and not mention it in the contract, assuming the buyer will understand it is not included. Option B. Advise the seller that the garage inclusion or exclusion must be clearly stipulated in the contract of purchase and sale, and if the seller intends to remove it, this must be explicitly stated as an exclusion, or if they intend to include it, it must be listed as an inclusion, with legal advice recommended if there is any doubt about its status as a fixture. Option C. Inform the seller that they can remove the garage after the sale is complete, as it is their personal property until possession is transferred. Option D. Proceed with the sale based on the seller's verbal assurance that they will remove the garage, without formally documenting its exclusion in the contract. The correct answer is B. Advise the seller that the garage inclusion or exclusion must be clearly stipulated in the contract of purchase and sale, and if the seller intends to remove it, this must be explicitly stated as an exclusion, or if they intend to include it, it must be listed as an inclusion, with legal advice recommended if there is any doubt about its status as a fixture. Explanation. This scenario is professionally challenging because it involves a potential conflict between a seller's stated intentions and the legal realities of property rights in British Columbia. A real estate licensee must navigate this delicate situation with utmost professionalism, ensuring full compliance with the Real Estate Services Act, RESA, and its associated rules, as well as ethical obligations to both clients and the public. The licensee's duty is to facilitate a transaction based on accurate information and legal understanding, not to act on assumptions or incomplete representations. The best approach involves clearly and accurately advising the seller on the implications of their property rights concerning the detached garage. This means explaining that while the seller may intend for the garage to remain with the property, its legal status as a fixture or chattel, and its potential to be removed, must be definitively established. The licensee must then ensure that the contract of purchase and sale accurately reflects the agreed-upon status of the garage, whether it is to be included as a fixture or excluded. This approach is correct because it upholds the licensee's duty of care, honesty, and integrity as mandated by RESA. It ensures transparency, protects both parties from future disputes, and aligns with the professional standard of providing accurate advice regarding property inclusions and exclusions. An incorrect approach would be to simply take the seller's word that the garage will remain without verifying its legal status or ensuring its inclusion in the contract. This fails to meet the duty of care and could lead to a breach of contract and professional misconduct, as the buyer might reasonably expect the garage to be included if it appears to be a permanent structure. Another incorrect approach would be to advise the seller that they can simply remove the garage after the sale, regardless of its apparent permanence or the buyer's expectations. This disregards the potential for the garage to be considered a fixture, which would legally transfer with the property, and could result in legal action and ethical violations. Finally, advising the seller to omit any mention of the garage in the contract, assuming it will be a point of negotiation later, is also professionally unsound. This creates ambiguity and a lack of clear agreement, which is contrary to the purpose of a formal contract and the licensee's obligation to ensure all material terms are clearly documented. Professional decision-making in such situations requires a systematic process. First, identify the core issue, the garage status and inclusion. Second, consult relevant legal principles and RESA requirements. Third, communicate clearly and factually with the client, the seller, explaining the legal implications. Fourth, document all advice and agreements meticulously in the contract of purchase and sale. And fifth, ensure all actions are transparent and in good faith towards all parties involved. Question 6. Investigation of the fundamental nature of real estate in British Columbia reveals various interpretations of its definition and significance. A real estate professional is asked by a new client to explain what real estate truly means beyond just the physical land and buildings. Which of the following approaches best demonstrates a comprehensive understanding of the definition and importance of real estate within the British Columbia regulatory framework? Option A. Defining real estate strictly as the physical land and any structures built upon it, focusing primarily on the tangible aspects that are visible and measurable. Option B. Presenting real estate as a static concept, unchanging in its definition and importance, and focusing only on historical precedents in property law. Option C. Explaining that real estate in British Columbia encompasses land, buildings, and all associated legal rights and interests, such as easements, covenants, and mineral rights, emphasizing their critical role in property value, transferability, and client asset protection under provincial law. Option D. Describing real estate as solely a vehicle for investment and profit, highlighting its importance in generating commissions for real estate professionals and wealth for investors. The correct answer is C. Explaining that real estate in British Columbia encompasses land, buildings, and all associated legal rights and interests, such as easements, covenants, and mineral rights, emphasizing their critical role in property value, transferability, and client asset protection under provincial law. Explanation. The scenario presents a common challenge for real estate professionals in British Columbia, understanding the fundamental definition and importance of real estate beyond mere physical property. This requires a nuanced appreciation of its legal, economic, and social dimensions, which underpins all brokerage activities. The best professional approach involves recognizing that real estate, as defined by the Real Estate Services Act, RESA, and its associated regulations in British Columbia, encompasses not only land and buildings, but also the rights and interests associated with them. This includes understanding the importance of these rights and interests in facilitating transactions, protecting client assets, and ensuring compliance with provincial laws. A broker must be able to articulate this comprehensive definition to clients, demonstrating their expertise and building trust. This approach prioritizes a thorough understanding of the legal framework governing real estate practice in BC, ensuring all advice and actions are grounded in regulatory requirements and ethical obligations. An incorrect approach would be to narrowly define real estate solely as physical structures and land. This overlooks the critical legal and economic aspects, such as easements, covenants, mineral rights, and leasehold interests, which are integral to property value and transferability in British Columbia. Failing to grasp these nuances can lead to incomplete advice, potential legal disputes, and a breach of the duty of care owed to clients under RESA. Another incorrect approach is to view the importance of real estate solely from a transactional perspective, focusing only on the commission earned. This ignores the broader societal and economic significance of real estate, including its role in wealth creation, community development, and individual security. Such a limited view can lead to prioritizing short-term gains over long-term client interests and may contravene the ethical principles of acting with integrity and in the best interests of clients as mandated by the Real Estate Services Act. A further incorrect approach would be to treat the definition and importance of real estate as a static concept, unchanging over time. Real estate law, market dynamics, and societal expectations evolve. A professional must stay abreast of these changes, understanding how new legislation, economic shifts, or environmental considerations might impact the definition and importance of real estate in British Columbia. Failure to do so can result in outdated advice and practices that are not compliant with current regulations or best practices. A professional reasoning process for navigating such situations should begin with a commitment to understanding the foundational legal definitions and principles governing real estate practice in British Columbia, as outlined in RESA and its regulations. This involves continuous learning and a proactive approach to staying informed about legal and market developments. When advising clients, professionals must prioritize clear communication, ensuring clients understand the full scope of what constitutes their real estate interests and the implications thereof. Ethical considerations, such as acting in the client's best interest and maintaining professional integrity, should guide all interactions and decisions. Question 7. Comparative studies suggest that when a real estate licensee in British Columbia is assisting a client with a property purchase that is contingent on obtaining mortgage financing, the licensee's role in the mortgage application process is crucial for client protection. Considering the regulatory framework governing real estate professionals in British Columbia, which of the following approaches best represents professional conduct and adherence to legal obligations? Option A. The licensee should inform the client that mortgage pre-approval is a minor step and can be addressed after the offer has been accepted, focusing primarily on securing the property first. Option B. The licensee should educate the client on the general steps of the mortgage application process, assist them in organizing necessary documentation, and strongly advise them to consult with a licensed mortgage broker or financial institution for expert advice and to complete the formal application. Option C. The licensee should leverage their network to recommend a specific mortgage lender and assist the client in completing the mortgage application form, vouching for the client's financial stability to expedite the approval. Option D. The licensee should fill out the mortgage application form for the client, using their best judgment to estimate the client's income and employment details if the client is unavailable to provide them immediately. The correct answer is B. The licensee should educate the client on the general steps of the mortgage application process, assist them in organizing necessary documentation, and strongly advise them to consult with a licensed mortgage broker or financial institution for expert advice, and to complete the formal application. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate licensee in British Columbia to navigate the complexities of mortgage applications while upholding their fiduciary duties to the client and adhering to provincial real estate regulations. The pressure to facilitate a sale can sometimes conflict with the obligation to ensure the client fully understands the financial implications and risks associated with their mortgage choices. Careful judgment is required to balance the client's immediate desire to secure financing with the long-term responsibility of ensuring they make informed decisions that align with their financial capacity and goals. Correct approach analysis. The best professional practice involves the licensee acting as a facilitator and educator, ensuring the client understands the mortgage application process and their responsibilities. This approach prioritizes client well-being and informed consent. The licensee should guide the client in gathering necessary documentation, explain the general steps involved in a mortgage application, and strongly advise them to seek independent professional advice from a qualified mortgage broker or financial institution. This aligns with the ethical obligation under the Real Estate Services Act, RESA, and its associated rules to act with honesty and integrity, and to avoid misrepresentation or misleading the client. By encouraging independent professional advice, the licensee ensures the client receives expert guidance tailored to their specific financial situation, thereby mitigating potential risks and fulfilling their duty of care. Incorrect approaches analysis. One incorrect approach involves the licensee actively recommending a specific mortgage lender or product without possessing the necessary licensing and expertise to provide such advice. This is a regulatory failure under RESA, as it constitutes providing financial advice or services for which the licensee is not authorized. It also creates a conflict of interest, as the licensee may be perceived to be acting in their own interest or the interest of the lender rather than solely the client's. Another incorrect approach is for the licensee to complete the mortgage application on behalf of the client, filling in details about their financial situation and employment without the client's direct input or verification. This is a serious breach of trust and potentially a misrepresentation of the client's financial standing to the lender. It bypasses the client's responsibility to provide accurate information and can lead to fraudulent applications, violating RESA provisions against misleading conduct. A third incorrect approach is to downplay the importance of the mortgage pre-approval process or to suggest that it is a mere formality that can be completed after the offer has been accepted. This is ethically unsound and potentially harmful to the client. Failing to emphasize the critical nature of pre-approval can lead to the client making an offer on a property they cannot afford, resulting in the loss of their deposit and significant financial distress. This demonstrates a lack of diligence and a failure to act in the client's best interest, contravening the duty of care expected of a real estate professional. Professional reasoning. Professionals should adopt a client-centric decision-making process that prioritizes transparency, education, and the client's informed consent. This involves clearly defining the scope of the licensee's role, which is to facilitate the real estate transaction, not to provide financial or mortgage advice. When dealing with mortgage applications, the professional's responsibility is to guide the client through the process, explain its significance, and strongly recommend seeking expert advice from licensed mortgage professionals. Any action that steps outside this defined role or could be construed as providing unauthorized financial services should be avoided. Maintaining clear communication, documenting all advice given, and ensuring the client understands their obligations and the risks involved are paramount to ethical practice. Question 8. The investigation demonstrates that a landlord in Vancouver, British Columbia, has a tenant who signed a 1-year fixed-term residential lease agreement that is set to expire in 6 months. The tenant has informed the landlord that they need to move out in 2 months due to unforeseen personal circumstances and is asking if they can be released from the lease agreement. What is the most appropriate course of action for the real estate licensee representing the landlord? Option A. Inform the landlord that the tenant is automatically released from all lease obligations once they vacate the property. Option B. Recommend that the landlord keep the entire security deposit to cover the remaining rent without making any efforts to re-rent the unit. Option C. Advise the landlord that the tenant is likely liable for rent until the end of the fixed term or until a new tenant is found, and that the landlord has a legal obligation to mitigate losses by actively seeking a replacement tenant. Option D. Advise the landlord to immediately initiate legal proceedings to recover the full rent for the remaining duration of the lease term. The correct answer is C. Advise the landlord that the tenant is likely liable for rent until the end of the fixed term or until a new tenant is found, and that the landlord has a legal obligation to mitigate losses by actively seeking a replacement tenant. Explanation. This scenario is professionally challenging because it requires a real estate licensee to navigate the complexities of lease agreements, specifically distinguishing between different types of leases and their implications for both landlords and tenants in British Columbia. Misunderstanding these distinctions can lead to significant legal and financial repercussions, impacting the licensee's reputation and potentially leading to disciplinary action. Careful judgment is required to ensure compliance with the Residential Tenancy Act (RTA) and to uphold ethical obligations to clients. The best approach involves accurately identifying the lease agreement as a fixed-term lease and advising the landlord on the implications of the tenant's request to vacate before the end of the term. This includes explaining the landlord's obligations under the RTA, such as the duty to mitigate losses by attempting to re-rent the property, and the tenant's potential liability for rent until the end of the term or until a new tenant is found. This approach is correct because it directly addresses the legal framework governing residential tenancies in British Columbia, specifically the RTA, which dictates the terms and conditions of fixed-term leases and the procedures for early termination. It prioritizes providing accurate legal information and guiding the landlord towards compliant actions, thereby protecting both parties and the licensee. An incorrect approach would be to advise the landlord that the tenant is automatically released from all obligations upon vacating the property. This is incorrect because fixed-term leases in British Columbia create a binding agreement for the entire term. The RTA does not automatically release a tenant from their obligations simply because they have vacated the premises before the lease end date. The landlord has a legal duty to mitigate their losses, and the tenant remains liable for rent until the landlord re-rents the unit or the lease term expires, whichever comes first. This approach fails to acknowledge the legal realities of fixed-term leases and the landlord's duty to mitigate. Another incorrect approach would be to suggest that the landlord can simply keep the security deposit to cover the remaining rent without making any attempts to re-rent the property. This is incorrect because the RTA outlines specific procedures for the application of security deposits, and landlords are legally obligated to mitigate their losses. Keeping the entire security deposit without attempting to re-rent would likely be considered a breach of the landlord's duty to mitigate and could result in the landlord being ordered to return the deposit and potentially pay compensation to the tenant. A further incorrect approach would be to advise the landlord to immediately pursue legal action against the tenant for the full amount of rent for the remainder of the lease term without any attempt to re-rent. While the tenant may be liable for rent, the landlord's duty to mitigate is a crucial factor. Failing to make reasonable efforts to re-rent the property before seeking full compensation can significantly impact the outcome of any legal proceedings and may lead to a court reducing the amount the landlord can recover. A professional decision-making process for similar situations should begin with a thorough understanding of the specific type of lease agreement in place and the relevant legislation, in this case, the British Columbia Residential Tenancy Act. Licensees must then analyze the tenant's request in light of these legal requirements. The next step is to clearly communicate the legal rights and obligations of both the landlord and the tenant to the landlord, emphasizing the landlord's duty to mitigate. Finally, licensees should advise the landlord on compliant courses of action, ensuring that all advice aligns with regulatory requirements and ethical standards. Question 9. In British Columbia, a real estate licensee is assisting a client who is purchasing a residential property. The client expresses concern about securing the best possible mortgage terms and asks the licensee for advice on which specific mortgage products and lenders would be most advantageous. What is the most appropriate course of action for the licensee to take? Option A. Offer to assist the client in completing mortgage application forms and negotiating terms directly with lenders on their behalf. Option B. Suggest that the client can likely find sufficient information and secure financing independently through online mortgage comparison websites without needing professional consultation. Option C. Advise the client on the importance of consulting with a licensed mortgage broker or financial institution to explore various financing options and secure expert advice tailored to their financial situation. Option D. Recommend specific mortgage products and lenders that the licensee believes offer the most competitive rates, based on general market knowledge. The correct answer is C. Advise the client on the importance of consulting with a licensed mortgage broker or financial institution to explore various financing options and secure expert advice tailored to their financial situation. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate licensee in British Columbia to navigate the complexities of financing options while prioritizing the client's best interests and adhering to provincial real estate regulations. The licensee must balance providing helpful information with avoiding the unauthorized practice of mortgage brokering or providing financial advice beyond their scope. Missteps can lead to regulatory breaches, ethical violations, and damage to client trust. Correct approach analysis. The best professional practice involves the licensee acting as a facilitator and educator, guiding the client to appropriate professionals. This approach correctly involves the licensee understanding the general financing landscape in British Columbia, including common mortgage types and the role of lenders and mortgage brokers. The licensee should then advise the client on the importance of obtaining independent financial advice from a qualified mortgage broker or financial institution. This aligns with the Real Estate Services Act, RESA, and the Real Estate Services Regulation, which define the scope of practice for real estate licensees and prohibit them from engaging in activities reserved for licensed mortgage brokers or financial advisors without proper licensing. The licensee's duty of care and fiduciary responsibility to the client mandates that they ensure the client receives expert advice from appropriately licensed professionals for complex financial matters like mortgage origination. Incorrect approaches analysis. One incorrect approach involves the licensee directly recommending specific mortgage products or lenders based on their perceived best rates, without the client first consulting an independent mortgage broker. This crosses the line into providing financial advice and potentially mortgage brokering services, which is a regulatory failure under RESA if the licensee is not licensed for those activities. It also bypasses the crucial step of independent professional assessment of the client's financial situation. Another incorrect approach is for the licensee to downplay the importance of professional mortgage advice, suggesting that the client can easily secure financing through online resources alone. This fails to uphold the licensee's duty of care and can expose the client to unsuitable or disadvantageous financing terms, potentially leading to financial hardship. It also neglects the licensee's obligation to ensure the client is adequately informed and supported in a significant financial transaction. A third incorrect approach is for the licensee to offer to help the client fill out mortgage applications or negotiate terms directly with lenders. This constitutes the unauthorized practice of mortgage brokering and financial advising, a clear violation of RESA and its regulations. The licensee's role is to facilitate the real estate transaction, not to perform the functions of a licensed mortgage professional. Professional reasoning. professionals should adopt a client-centric approach that prioritizes informed decision-making. This involves understanding the boundaries of their own licensing and expertise. When a situation involves specialized financial advice, such as mortgage origination, the professional's role is to educate the client about the need for such advice and to guide them towards qualified, licensed professionals. Clear process involves 1. Identifying the client's need for financing. 2. Explaining the general financing process and the roles of various professionals. 3. Strongly recommending consultation with a licensed mortgage broker or financial institution. 4. Providing contact information for reputable professionals if requested, but not endorsing specific ones over others without due diligence. And 5. Focusing on the real estate transaction itself, ensuring all legal and contractual aspects are handled correctly. Question 10. System analysis indicates a prospective buyer in British Columbia wishes to purchase a property for $600,000 and has secured a pre-approval for a mortgage. The property has been appraised at $580,000. The buyer intends to utilize a government-backed mortgage program administered by the Canada Mortgage and Housing Corporation, CMHC, with a maximum loan-to-value (LTV) ratio of 95%. The buyer's pre-approval is for a maximum of $550,000, and their debt servicing capacity supports this amount. What is the maximum government-backed loan amount the buyer can obtain for this property? Option A, $570,000. Option B, $580,000. Option C, $550,000. Option D, $590,000. The correct answer is C, $550,000. Explanation: scenario analysis. This scenario is professionally challenging because it requires a real estate licensee in British Columbia to accurately calculate the maximum loan amount for a buyer utilizing a government-backed mortgage program, while also considering the buyer's specific financial situation and the property's appraised value. Miscalculations can lead to significant financial repercussions for the buyer, potentially jeopardizing the sale and damaging the licensee's reputation and professional standing. Adherence to the specific guidelines of the Canada Mortgage and Housing Corporation, CMHC, is paramount. Correct approach analysis. The best professional practice involves first determining the maximum insurable loan amount based on CMHC guidelines for the specific loan-to-value ratio and the property's purchase price or appraised value, whichever is lower. This calculated amount is then compared to the buyer's pre-approval limit and their ability to service the debt. The maximum loan the buyer can obtain is the lesser of these figures. This approach is correct because it directly applies CMHC underwriting principles, which prioritize the lower of the purchase price or appraised value for loan security, and ensures the loan amount is within both the government program's limits and the buyer's financial capacity, thereby complying with regulatory requirements and ethical obligations to the client. Incorrect approaches analysis. One incorrect approach is to solely rely on the buyer's pre-approval amount without verifying it against CMHC maximum insurable loan limits or the property's valuation. This fails to account for the specific constraints of government-backed programs and could lead to a loan amount exceeding CMHC allowable limits or the property's security value, potentially causing the mortgage to be denied. Another incorrect approach is to calculate the loan based on the appraised value alone, ignoring the purchase price. CMHC guidelines stipulate that the loan amount cannot exceed the lesser of the purchase price or the appraised value, as this protects the lender and the insurer. Basing the calculation solely on the appraised value could result in an overestimation of the loan amount. A further incorrect approach is to calculate the maximum loan based on the buyer's stated income and debt-to-income ratios without considering the CMHC loan-to-value limits or the property's valuation. While debt servicing capacity is crucial, it does not override the fundamental loan limits imposed by the government-backed program and the property's market value. Professional reasoning. Professionals should always begin by understanding the specific government-backed mortgage program's guidelines, in this case, CMHC. They must then gather all relevant financial information from the buyer and the property details, including the purchase price and appraised value. The calculation should always adhere to the principle of using the lower of the purchase price or appraised value for loan security. The resulting figure is then cross-referenced with the buyer's pre-approval and their debt servicing capabilities to determine the actual maximum loan. This systematic approach ensures compliance, protects the client's interests, and mitigates risk. Question 11. Regulatory review indicates that a real estate professional in British Columbia is representing a buyer interested in a property where the seller has indicated they have an existing mortgage that will be paid off upon sale. What is the most prudent course of action for the real estate professional to ensure the buyer's interests are protected regarding this financing aspect? Option A. Rely on the seller's verbal assurance that the mortgage will be paid off at closing and proceed with the transaction. Option B. Advise the buyer to secure their own financing immediately, assuming the seller's mortgage will be handled without further investigation. Option C. Obtain a written statement from the seller's lender detailing the exact outstanding mortgage balance and the required steps for its discharge, and confirm this with the seller's legal representative. Option D. Accept the seller's offer to provide a personal check for the estimated mortgage payout amount at the time of closing. The correct answer is C. Obtain a written statement from the seller's lender detailing the exact outstanding mortgage balance and the required steps for its discharge, and confirm this with the seller's legal representative. Explanation. Scenario analysis. This scenario presents a professional challenge due to the potential for undisclosed encumbrances on a property, which directly impacts the buyer's security and the integrity of the transaction. A real estate professional in British Columbia must navigate the complexities of property financing and disclosure obligations to protect their clients' interests and uphold their professional duties under the Real Estate Services Act, RESA, and its associated rules. The pressure to close a deal quickly can sometimes lead to overlooking crucial due diligence steps, making careful judgment paramount. Correct approach analysis. The best professional practice involves diligently verifying the existence and terms of any existing mortgage or financing agreements registered against the property title. This includes obtaining a copy of the mortgage statement from the seller's lender, confirming the outstanding balance, and understanding the conditions for discharge. This approach is correct because it directly addresses the fundamental requirement of ensuring clear title for the buyer, as mandated by RESA and the common law duty of care owed to clients. It proactively identifies and mitigates the risk of the buyer inheriting an encumbrance or facing complications during the title transfer process. This thoroughness aligns with the ethical obligation to act with honesty and integrity and to represent the client's best interests. Incorrect approaches analysis. Proceeding with the assumption that the seller's verbal assurance is sufficient is professionally unacceptable. This fails to meet the standard of care required by RESA, which necessitates written confirmation and verification of all material facts. Relying solely on verbal assurances leaves the buyer vulnerable to undisclosed financial obligations and potential legal disputes. Accepting the seller's offer to simply pay off the mortgage at closing, without independent verification of the exact amount, and the lender's discharge process is also professionally flawed. This approach bypasses essential due diligence, as the actual payout amount may differ from the seller's estimate, potentially leading to shortfalls or delays. It also neglects the formal requirements for mortgage discharge, which can involve specific timelines and documentation. Suggesting the buyer obtain their own financing without first clarifying the status of the seller's existing mortgage is a misdirection of professional responsibility. While the buyer's financing is crucial, the primary obligation at this stage is to ensure the seller can provide clear title. This approach fails to address the immediate encumbrance issue and could lead to unnecessary complications and costs for the buyer if the seller's mortgage is not properly handled. Professional reasoning. Professionals should adopt a systematic approach to property financing verification. This involves 1. Identifying all potential encumbrances through title searches. 2. Requesting and reviewing all relevant documentation from the seller regarding existing financing. 3. Verifying information directly with lenders where possible and appropriate. 4. Clearly communicating all findings and potential risks to the buyer. 5. Ensuring all conditions for title transfer, including mortgage discharge, are met before closing. This structured process minimizes risk and upholds professional standards. Question 12. Consider a scenario in British Columbia where a real estate licensee is listing a property that was previously used for light industrial purposes, and there are rumors in the neighborhood about potential soil contamination from past activities. The seller states they are unaware of any environmental issues and has not conducted any testing. What is the most responsible course of action for the licensee to take regarding potential environmental concerns? Option A. Recommend to both the seller and potential buyers that a qualified environmental professional conduct a Phase I environmental site assessment to identify any potential contamination. Option B. Suggest that the buyer should independently investigate any potential environmental concerns if they choose to make an offer on the property. Option C. Inform potential buyers about the neighborhood rumors, but downplay the significance of these rumors to avoid deterring interest in the property. Option D. Advise the seller that since they are unaware of any issues, the licensee will not mention the rumors to potential buyers to avoid complicating the sale. Correct answer is A. Recommend to both the seller and potential buyers that qualified environmental professional conduct a Phase I environmental site assessment to identify any potential contamination. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate licensee in British Columbia due to the potential for undisclosed environmental liabilities to significantly impact property value and buyer confidence. The licensee's duty of care, fiduciary responsibilities, and obligations under the Real Estate Services Act, RESA, and its associated rules require them to act with honesty and integrity, and to disclose all material latent defects. Failure to adequately address environmental concerns can lead to legal repercussions, disciplinary action from the Real Estate Council of British Columbia, and damage to the licensee's reputation. The complexity arises from the need to balance the seller's desire for a smooth transaction with the buyer's right to be fully informed about potential risks. Correct approach analysis. The best professional approach involves proactively identifying potential environmental concerns and recommending a qualified environmental assessment. This aligns with the licensee's duty to disclose material latent defects and to act in the best interest of their client, while also upholding ethical standards. By suggesting a professional assessment, the licensee facilitates informed decision-making for both parties. This approach demonstrates due diligence, mitigates risk for the licensee, and ensures compliance with RESA and the rules, which mandate disclosure of known or reasonably discoverable material facts. It also respects the principle of caveat emptor by providing the buyer with the tools to investigate further, rather than relying solely on the seller's representations or the licensee's limited expertise. Incorrect approaches analysis. Relying solely on the seller's verbal assurances without further investigation is professionally unacceptable. This approach fails to meet the licensee's obligation to disclose material latent defects, as environmental contamination is often not visible or discoverable through ordinary inspection. It places undue trust in the seller's potentially incomplete or biased information and exposes the buyer to significant undisclosed risks, violating RESA and the rules. Minimizing the potential environmental concerns to the buyer to avoid jeopardizing the sale is also professionally unacceptable. This constitutes a failure to disclose material facts and a breach of the licensee's duty of honesty and integrity. Such an action prioritizes the transaction over the client's well-being and the integrity of the market, leading to potential legal liability and disciplinary action. Suggesting that the buyer obtain an environmental assessment only if they specifically ask about potential contamination is also insufficient. While the buyer has the right to investigate, the licensee has a proactive duty to disclose known or reasonably discoverable material facts. Environmental issues can be material latent defects, and the licensee should not wait for the buyer to prompt them if there are indicators of potential concern. This approach shifts the burden of discovery entirely to the buyer, which may not be appropriate when the licensee has reason to believe a material fact exists. Professional reasoning. Professionals in British Columbia real estate should adopt a risk-based approach to property disclosures. When presented with a property that has a history or characteristics suggesting potential environmental concerns, e.g., former industrial use, proximity to known contamination sites, presence of underground storage tanks, the licensee's professional judgment should trigger a recommendation for further investigation. This involves understanding the scope of their disclosure obligations under RESA and the rules, recognizing that environmental issues can be material latent defects, and prioritizing client well-being and market integrity. The decision-making process should involve 1. Identifying potential red flags. 2. Assessing the materiality of the potential issue. 3. recommending appropriate professional assessments to mitigate risk and ensure informed consent. 4. Documenting all advice and actions taken. Question 13. Upon reviewing the mortgage commitment for a client purchasing a property in Vancouver, British Columbia, you notice a condition requiring private mortgage insurance, PMI, due to the loan-to-value ratio. What is the most appropriate course of action for you, as the real estate licensee, to ensure your client is adequately informed and protected? Option A. Inform the client that PMI is a standard administrative fee that is usually not significant and is simply a formality for obtaining the mortgage. Option B. Advise the client on whether the PMI cost is reasonable for their financial situation and suggest alternative lenders who might not require it, based on your general knowledge of the market. Option C. Clearly explain to the client that PMI is a lender requirement to mitigate their risk, detailing its general purpose and cost to the borrower, while advising them to consult their mortgage broker or financial advisor for specific advice on the policy. Option D. State to the client that PMI is a mandatory insurance that protects their home and that you will handle the details of obtaining it for them. The correct answer is C. Clearly explain to the client that PMI is a lender requirement to mitigate their risk, detailing its general purpose and cost to the borrower, while advising them to consult their mortgage broker or financial advisor for specific advice on the policy. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate licensee in British Columbia to navigate the complexities of private mortgage insurance, PMI, in the context of a client's financial situation and the lender's requirements. The licensee must balance their fiduciary duty to the client with the practicalities of securing financing, ensuring transparency, and avoiding misrepresentation. The core challenge lies in accurately assessing the client's understanding and the implications of PMI without providing financial advice, which falls outside the scope of a real estate licensee's authority. Correct approach analysis. The best professional practice involves clearly and comprehensively explaining to the client that private mortgage insurance is a requirement from the lender to mitigate their risk, not a service provided by the real estate brokerage. This explanation should detail what PMI generally covers, protecting the lender against default, the typical circumstances under which it is mandated, e.g., high loan-to-value ratios, and that the cost is borne by the borrower. Crucially, the licensee must emphasize that they are not qualified to advise on the financial merits or specific terms of the PMI policy, and that the client should consult with their mortgage broker or financial advisor for personalized guidance. This approach aligns with the ethical obligations under the Real Estate Services Act, RESA, and the rules of the Real Estate Council of British Columbia, REC, which mandate honesty, integrity, and acting in the best interests of the client while respecting professional boundaries. It ensures the client is informed about a material condition of their financing without the licensee overstepping their expertise. Incorrect approaches analysis. One incorrect approach is to simply state that PMI is a standard requirement without elaborating on its purpose or implications for the client. This fails to meet the duty of disclosure and can leave the client uninformed about a significant cost and condition of their mortgage, potentially leading to misunderstandings or dissatisfaction later. It also risks implying that the licensee has fully addressed the client's understanding of this financial component. Another incorrect approach is to downplay the significance of PMI, suggesting it is a minor administrative detail. This misrepresents the financial impact of PMI, which can be a substantial cost for the borrower. Such an approach violates the principle of honesty and integrity, as it fails to provide a true and fair representation of the transaction's financial aspects. A further incorrect approach is to offer an opinion on whether the client should proceed with the mortgage based on the PMI cost, or to suggest alternative lenders that might not require it without a thorough understanding of the client's overall financial picture and the specific terms offered by other institutions. This constitutes providing financial advice, which is outside the scope of a real estate licensee's license and could lead to liability if the advice proves detrimental to the client. Professional reasoning. Professionals should adopt a framework of informed disclosure and professional boundaries. When encountering a requirement like PMI, the licensee's first step is to understand its role in the transaction. Next, they must clearly communicate this role to the client, explaining what it is, why it's required by the lender, and who bears the cost. Simultaneously, they must identify and clearly communicate their limitations, advising the client to seek expert advice from qualified professionals, e.g., mortgage brokers, financial advisors, for any specific financial guidance or policy evaluation. This ensures the client is empowered with information and directed to appropriate resources, upholding the licensee's ethical and legal obligations. Question 14. When evaluating a client's interest in investing in a real estate investment trust REIT in British Columbia, which of the following approaches best aligns with a real estate licensee's professional obligations and regulatory framework? Option A. Advise the client to invest in a REIT based solely on its current market price, without discussing the underlying assets or management structure. Option B. Assure the client that REIT are a low-risk investment with guaranteed returns, encouraging them to invest a significant portion of their savings. Option C. Explain the general nature and structure of REIT as a real estate investment vehicle, discuss how they operate within the British Columbia market, and advise the client to consult with a licensed financial planner for specific investment advice. Option D. Recommend a specific REIT that has shown strong historical dividend performance, suggesting it as a sound investment for the client's portfolio. The correct answer is C. Explain the general nature and structure of REIT as a real estate investment vehicle, discuss how they operate within the British Columbia market, and advise the client to consult with a licensed financial planner for specific investment advice. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate licensee in British Columbia to balance their fiduciary duty to a client with the complexities of advising on a real estate investment trust REIT. The client's understanding of REIT may be limited, and the licensee must ensure they are providing advice that is within their scope of practice and compliant with the Real Estate Services Act, RESA, and its regulations, as well as any relevant BCREA guidelines. Misrepresenting the nature of a REIT or failing to disclose material risks could lead to significant legal and ethical repercussions. The core challenge lies in distinguishing between providing general information about investment vehicles and offering specific investment advice, which typically requires licensing as a financial advisor. Correct approach analysis. The best professional approach involves clearly delineating the scope of services. A licensee should explain that while they can provide general information about REIT as an investment vehicle, including their structure and how they operate within the real estate market in British Columbia, they cannot provide specific investment advice or recommendations. This approach is correct because it aligns with the licensee's obligations under RESA to act with honesty and integrity, and to not engage in activities for which they are not qualified or licensed. It also respects the client's need for specialized financial advice by recommending they consult with a licensed financial planner or investment advisor. This upholds the principle of client best interest by ensuring the client receives appropriate expertise for investment decisions, while the licensee stays within their authorized professional boundaries. Incorrect approaches analysis. Recommending a specific REIT without a thorough understanding of the client's financial situation, risk tolerance, and investment objectives, and without being licensed to provide such advice, is a significant regulatory and ethical failure. This constitutes providing investment advice, which falls outside the scope of a real estate licensee's authority under RESA and could lead to liability for losses incurred by the client. It also breaches the duty of care by not ensuring the advice is suitable, suggesting that a REIT is a guaranteed investment or downplaying its inherent risks, such as market fluctuations, interest rate sensitivity, or management fees, is also professionally unacceptable. This misrepresentation violates RESA requirement for licensees to be truthful and not mislead clients. It fails to disclose material facts about the investment, which is a fundamental ethical obligation. Advising the client to invest in a REIT solely based on its historical dividend payouts, without discussing the underlying real estate assets, the REIT management, or its overall financial health, is an incomplete and potentially misleading approach. While historical performance can be a factor, it is not a guarantee of future results, and a comprehensive understanding of the investment's fundamentals is crucial. This approach risks oversimplifying a complex investment and failing to provide the client with a balanced perspective, thereby not acting in the client's best interest. Professional reasoning. Professionals in British Columbia must adopt a framework that prioritizes client protection and regulatory compliance. This involves a clear understanding of one's scope of practice and licensing limitations. When a client expresses interest in investment vehicles like REIT, the licensee should first assess their own knowledge and licensing. If the topic extends beyond general information about real estate ownership and into specific investment recommendations or financial planning, the licensee must recognize their limitations. The professional decision-making process should involve 1. Identifying the client's need. 2. Assessing the licensee's capacity to meet that need within regulatory boundaries. 3. Providing accurate, general information where appropriate. 4. Clearly stating limitations and avoiding advice outside their expertise. And 5. Referring the client to other qualified professionals when necessary. This ensures that the client receives comprehensive and appropriate guidance, while the licensee maintains professional integrity and adheres to the Real Estate Services Act. Question 15. The analysis reveals that a real estate investor in British Columbia requires immediate financing to secure a distressed property. The investor is eager to close quickly and has expressed concerns about qualifying for traditional mortgages. As a real estate professional, what is the most prudent course of action to assist this investor in exploring financing options? Option A. Immediately connect the investor with a hard money lender known for fast approvals, emphasizing the speed of the process and downplaying any potential higher interest rates or shorter repayment terms. Option B. Suggest that the investor offer a significantly lower purchase price to the seller in exchange for the seller providing financing, without fully explaining the potential complexities or the seller's motivations. Option C. Advise the investor to wait and pursue traditional mortgage financing, even though it may not meet their immediate need for speed, to avoid the perceived complexities of alternative financing. Option D. Provide a comprehensive overview of both hard money loans and seller financing, detailing their respective characteristics, associated costs, risks, and benefits, while strongly advising the investor to seek independent legal and financial counsel to review any proposed agreements. The correct answer is D. Provide a comprehensive overview of both hard money loans and seller financing, detailing their respective characteristics, associated costs, risks, and benefits, while strongly advising the investor to seek independent legal and financial counsel to review any proposed agreements. Explanation. The analysis reveals a scenario where a real estate investor in British Columbia is seeking rapid financing for a distressed property acquisition. This situation is professionally challenging because the urgency of the deal, coupled with the investor's potential lack of traditional lending qualifications, creates a high-pressure environment where quick decisions are paramount. The temptation to overlook due diligence or regulatory compliance in favor of speed is significant. Careful judgment is required to balance the investor's needs with the legal and ethical obligations of the real estate professional. The correct approach involves the real estate professional thoroughly explaining the nature of hard money loans, including their typically higher interest rates, shorter terms, and the fact that they are asset-based rather than borrower-based. This explanation must also cover the potential risks and benefits of seller financing, emphasizing the importance of independent legal and financial advice for the investor to understand the terms, repayment schedules, and any security interests involved. This approach is correct because it aligns with the principles of informed consent and professional duty of care mandated by the Real Estate Services Act (RESA) of British Columbia and the Real Estate Council of British Columbia's (REC) Rules of Conduct. Professionals are obligated to provide clients with accurate and comprehensive information to enable them to make informed decisions and to avoid misrepresentation or undue influence. An incorrect approach would be to solely focus on the speed of hard money loans without adequately disclosing the associated costs and risks, or to steer the investor towards seller financing without ensuring they understand the implications of such an arrangement, potentially leading to future disputes or financial hardship for the investor. This fails to meet the standard of care and may constitute a breach of fiduciary duty. Another incorrect approach would be to recommend a financing option without advising the investor to seek independent legal and financial counsel, thereby failing to ensure the client is fully protected and understands the complexities of the agreement, which is a critical component of responsible real estate practice in British Columbia. Professional reasoning in such situations requires a structured decision-making process. First, identify the client's primary objective, rapid acquisition. Second, assess the client's financial situation and risk tolerance. Third, present all viable financing options, clearly outlining the pros and cons of each, with a strong emphasis on transparency regarding costs, terms, and risks. Fourth, strongly advise the client to obtain independent legal and financial advice for any complex financing arrangements. Finally, document all discussions and advice provided to the client. Question 16. Cost-benefit analysis shows that securing a mortgage quickly is paramount for a client purchasing a property in British Columbia. The client has indicated they can provide a significant portion of the down payment from a source they describe as personal savings, but they are hesitant to provide detailed documentation for this source, citing privacy concerns. What is the most prudent course of action for the real estate licensee to ensure the loan underwriting and approval process proceeds smoothly and ethically? Option A. Proactively contact the mortgage lender to clarify their specific requirements regarding down payment sources and documentation, and then advise the client on how to meet those requirements while respecting their privacy as much as possible. Option B. Accept the client's assurance of personal savings and proceed with the mortgage application, assuming the lender will approve it if the overall financial picture is strong. Option C. Advise the client to simply state personal savings on the mortgage application and let the lender request further details if they deem it necessary. Option D. Suggest the client explore alternative, less documented sources of funds that might be more readily available to avoid lender scrutiny. The correct answer is A. Proactively contact the mortgage lender to clarify their specific requirements regarding down payment sources and documentation, and then advise the client on how to meet those requirements while respecting their privacy as much as possible. Explanation. This scenario presents a professional challenge for a real estate licensee in British Columbia because it involves balancing the client's immediate financial needs with the lender's underwriting requirements and the licensee's fiduciary duties. The licensee must act in the best interest of their client, while also ensuring the integrity of the transaction and compliance with provincial real estate regulations. Misjudging the lender's requirements or misrepresenting information can lead to significant legal and ethical repercussions. The best approach involves proactively communicating with the lender to understand their specific underwriting criteria, and then advising the client on realistic financing options based on that information. This demonstrates due diligence and a commitment to transparency. By gathering clear information from the lender about acceptable down payment sources and required documentation, the licensee can accurately guide the client, manage expectations, and prevent potential deal collapse due to financing issues. This aligns with the ethical obligation under the Real Estate Services Act, RESA, to act with integrity and competence, and to avoid misrepresentation. An approach that involves accepting funds from an unverified source without confirming its acceptability with the lender is professionally unacceptable. This could violate RESA provisions against misrepresentation and fraudulent conduct, as it could lead to the lender rejecting the mortgage application. Furthermore, failing to disclose the nature of the down payment to the lender, if it deviates from standard acceptable sources, could be considered a material omission, jeopardizing the entire transaction and the licensee's professional standing. Another unacceptable approach is to pressure the client to provide documentation that may not be entirely accurate to satisfy the lender. This directly contravenes the licensee's duty of honesty and integrity and could expose both the client and the licensee to severe penalties under RESA and potentially criminal charges related to fraud. Finally, advising the client to simply figure it out with the lender, without providing any guidance or attempting to understand the lender's requirements abdicates the licensee's responsibility. While the ultimate approval rests with the lender, the licensee has a duty to facilitate the transaction by providing informed advice and ensuring all parties understand the process and requirements. Professionals should approach such situations by prioritizing clear, upfront communication with all parties involved, especially the lender. They must thoroughly understand the lender's underwriting guidelines and then translate that information into actionable advice for their client, managing expectations realistically and ethically. Question 17. Implementation of a landlord's decision to sell a tenanted property in British Columbia requires a property manager to navigate several legal and ethical considerations. If a landlord instructs their property manager to immediately begin showing the property to potential buyers, and to inform the tenant that they must vacate within 2 weeks to facilitate the sale, what is the most appropriate course of action for the property manager to take? Option A. Advise the landlord that they can ask the tenant to leave immediately, as the property is being sold, and this is a reasonable request. Option B. Inform the landlord that the tenant must be provided with proper legal notice to end the tenancy for sale, which includes a specific notice period and compensation, and that showings must respect the tenant's right to quiet enjoyment with appropriate notice. Option C. Proceed with showing the property to potential buyers without further notice to the tenant, assuming the tenant will understand the urgency of the sale. Option D. Inform the tenant that they must vacate within 2 weeks and assist the landlord in finding a new, comparable rental property for the tenant. The correct answer is B. Inform the landlord that the tenant must be provided with proper legal notice to end the tenancy for sale, which includes a specific notice period and compensation, and that showings must respect the tenant's right to quiet enjoyment with appropriate notice. Explanation. Scenario analysis. This scenario presents a common challenge in property management, balancing the financial interests of the property owner with the legal and ethical obligations to tenants, all within the specific regulatory framework of British Columbia. The challenge lies in interpreting and applying the Residential Tenancy Act, RTA, and its associated regulations to a situation where a landlord's desire for a quick sale might conflict with a tenant's right to quiet enjoyment and undisturbed possession. The property manager must navigate these competing interests while maintaining professional integrity and adhering to legal requirements, avoiding actions that could lead to disputes, legal challenges, or disciplinary action from the Real Estate Council of British Columbia. Correct approach analysis. The best approach involves a thorough understanding of the landlord's rights and obligations under the RTA, particularly concerning ending a tenancy for the purpose of sale. This requires providing the tenant with the legally mandated notice period, typically 2 months' notice, effective the end of a rental period, with specific forms and delivery methods required, and ensuring the tenant is compensated with 1 month's rent as per the RTA. The property manager must also facilitate showings in a manner that respects the tenant's right to quiet enjoyment, which includes providing reasonable notice for showings, typically 24 hours written notice, and ensuring showings are conducted at reasonable times. This approach prioritizes legal compliance and ethical treatment of the tenant, thereby protecting both the tenant and the landlord from potential legal repercussions and maintaining the property manager's professional standing. Incorrect approaches analysis. Pressuring the tenant to vacate without proper legal notice or compensation is a direct violation of the RTA. This disregards the tenant's legal rights and could result in the landlord being ordered to pay significant compensation to the tenant, as well as facing penalties from the Real Estate Council of British Columbia. Agreeing to the landlord's request to show the property to prospective buyers without providing the tenant with the legally required notice for showings undermines the tenant's right to quiet enjoyment. This can lead to tenant complaints, potential legal action, and damage to the property manager's reputation. Suggesting to the landlord that they can simply ask the tenant to leave without following the formal notice procedures outlined in the RTA is negligent and unprofessional. This demonstrates a lack of understanding of the governing legislation and exposes both the landlord and the property manager to legal and ethical liabilities. Professional reasoning. Property managers must adopt a proactive and informed approach. This involves staying current with the Residential Tenancy Act and its amendments, understanding the rights and responsibilities of both landlords and tenants, and maintaining clear, documented communication with all parties. When faced with a situation like this, a property manager should first consult the RTA to determine the correct legal procedures for ending a tenancy for sale. They should then communicate these procedures clearly to the landlord, explaining the legal requirements and the tenant's rights. The property manager should then implement these procedures diligently, ensuring all notices are served correctly, compensation is provided, and showings are conducted with appropriate notice and respect for the tenant's quiet enjoyment. This systematic, legally compliant, and ethically sound process is crucial for effective and responsible property management in British Columbia. Question 18. To address the challenge of a developer proposing a high-density residential project in Surrey, British Columbia, that appears to exceed the current zoning allowances, what is the most prudent and legally compliant course of action for a real estate professional representing the developer? Option A. Focus solely on marketing the property's potential based on the developer's aspirations, without delving into the specifics of current zoning regulations. Option B. Suggest the developer explore options for lobbying local council members to change the zoning bylaws to accommodate their project before submitting any formal application. Option C. Immediately consult the City of Surrey's official zoning bylaws and engage with the Municipal Planning Department to understand the specific regulations and potential avenues for development. Option D. Advise the developer to proceed with the application based on their initial vision, assuming that negotiations with the city can resolve any discrepancies later. Correct answer is C. Immediately consult the City of Surrey's official zoning bylaws and engage with the Municipal Planning Department to understand the specific regulations and potential avenues for development. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate professional to navigate conflicting stakeholder interests while adhering to the specific zoning bylaws of British Columbia. The developer's desire for maximum density clashes with the existing neighborhood character and potential infrastructure strain, necessitating a balanced approach that respects both private development goals and public land use objectives. Failure to do so can lead to significant delays, legal challenges, and damage to the professional's reputation. Correct approach analysis. The best professional approach involves proactively engaging with the local municipal planning department early in the process. This means understanding the specific zoning bylaws applicable to the property in Surrey, British Columbia, and identifying any official community plans or development permits that govern land use in that area. By consulting with the municipality, the agent can accurately advise the developer on the feasibility of their proposed density, potential amendments required, and the established process for such applications. This aligns with the professional obligation to provide accurate and informed advice, grounded in the specific regulatory framework of British Columbia, and fosters a collaborative approach to development that respects established land use policies. Incorrect approaches analysis. Pursuing the development application without first thoroughly understanding the Surrey zoning bylaws and municipal planning department's requirements is a significant regulatory failure. This approach risks submitting an application that is fundamentally non-compliant, leading to rejection and wasted resources for the developer. Another incorrect approach is to solely rely on the developer's initial vision without independent verification of zoning compliance. This demonstrates a lack of due diligence and a failure to uphold the professional duty to provide accurate advice based on established regulations. Finally, attempting to bypass or lobby for exceptions to established zoning bylaws without a clear understanding of the municipal process and the rationale behind the bylaws is unprofessional and likely to be unsuccessful, potentially creating adversarial relationships with the municipality. Professional reasoning. Professionals should adopt a systematic approach when dealing with zoning and land use. This involves 1. Identifying the specific municipality and relevant bylaws. 2. Consulting official municipal planning documents and departments. 3. Advising clients based on factual regulatory information. 4. Facilitating communication between stakeholders and the municipality. 5. Understanding the process for variances or amendments if initial proposals are not compliant. This structured decision-making process ensures compliance, manages client expectations, and promotes responsible development within the legal framework of British Columbia. Question 19. Examination of the data shows a property in Vancouver, British Columbia, is held by an individual with the absolute right to possess, use, and dispose of it indefinitely, with no specified end date to their ownership and no other parties holding a concurrent ownership interest. Based on this information, what is the most accurate classification of this ownership type under British Columbia real estate law? Option A. Tenancy in common. Option B. Fee simple. Option C. Joint tenancy. Option D. Leasehold. The correct answer is B. Fee simple. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate professional in British Columbia to navigate the complexities of different ownership structures when advising clients. Misunderstanding or misrepresenting these structures can lead to significant legal and financial consequences for the clients, potentially resulting in litigation and damage to the professional's reputation and licensing. Careful judgment is required to accurately identify and explain the implications of each ownership type to ensure informed decision-making by the client. Correct approach analysis. The best professional practice involves accurately identifying the ownership structure as fee simple. Fee simple ownership under British Columbia law represents the most complete form of ownership, granting the owner the right to possess, use, and dispose of the property indefinitely, subject only to governmental powers like taxation and eminent domain, and any registered encumbrances. This aligns with the description of the property being owned outright with no time limitations or shared ownership interests specified. Incorrect approach is analysis. One incorrect approach would be to identify the ownership as leasehold. Leasehold ownership involves the right to occupy and use a property for a specific period under a lease agreement, with the ultimate ownership remaining with the landlord. This is fundamentally different from outright ownership, and would be incorrect if the property is owned without such a time limitation or landlord. Another incorrect approach would be to identify the ownership as joint tenancy. Joint tenancy in British Columbia includes the right of survivorship, meaning that upon the death of one joint tenant, their interest automatically passes to the surviving joint tenant. If the property is owned by a single individual or by multiple individuals without this specific right of survivorship, then joint tenancy is not the correct classification. A further incorrect approach would be to identify the ownership as tenancy in common. Tenancy in common in British Columbia allows for distinct, undivided interests in a property, and importantly, does not include the right of survivorship. Each co-owner can sell or bequeath their share independently. If the property is owned by a single individual, or if the ownership structure is not specified as having distinct, inheritable shares, then tenancy in common would be an inaccurate classification. Professional reasoning. Professionals should always begin by thoroughly reviewing all available documentation related to the property, including title searches and any agreements of purchase and sale. They must then apply their knowledge of British Columbia's property law to accurately classify the ownership structure. When advising clients, professionals should clearly explain the rights, responsibilities, and implications of each ownership type, using plain language and avoiding jargon. If there is any ambiguity, the professional should seek clarification from legal counsel or advise the client to do so. The paramount duty is to act in the client's best interest, which includes providing accurate and comprehensive information. Question 20. Research into real estate market trends in British Columbia indicates that the average annual property appreciation over the past 15 years has been 5.2%. However, current market indicators suggest the province is in the late expansionary phase of its real estate cycle. A client is considering purchasing an investment property and asks for a projection of potential appreciation over the next 5 years. If the current trend of the late expansionary phase suggests a potential moderation in the rate of appreciation to an average of 3.5% annually for the next 5 years, what will be the projected value of a $500,000 property after 5 years under this scenario? Option A, $630,000. Option B, $591,510,000. Option C, $575,000. Option D, $581,000. The correct answer is B, $591,510,000. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate licensee in British Columbia because it requires them to go beyond simply presenting market data and instead interpret that data within the context of real estate cycles to provide informed advice. The challenge lies in accurately assessing the current phase of the market cycle and projecting its potential impact on property values and investment returns, which directly influences a client's financial decisions and the licensee's fiduciary duty. Misinterpreting the cycle can lead to poor investment advice, financial losses for the client, and potential professional liability. Correct approach analysis. The best professional practice involves calculating the average annual appreciation rate over a defined historical period, and then projecting this rate forward, adjusted for the current identified phase of the real estate cycle in British Columbia. This approach is correct because it grounds the projection in historical performance while acknowledging the dynamic nature of real estate markets. The licensee must demonstrate due diligence by using a reasonable historical timeframe, e.g., 10-20 years, to capture multiple market cycles, thus providing a more robust average. The adjustment for the current cycle phase, e.g., expansion, peak, contraction, trough, is crucial for providing realistic expectations and aligning with the principles of providing competent and diligent service as mandated by the Real Estate Services Act and the rules of the Real Estate Council of British Columbia. This demonstrates an understanding of market dynamics and a commitment to client-centric advice. Incorrect approach is analysis. One incorrect approach involves solely relying on the most recent year's appreciation rate without considering the broader historical context or the current market cycle. This is professionally unacceptable because it ignores the inherent volatility of real estate and fails to account for cyclical downturns that could significantly impact a client's investment. It violates the duty of care by presenting a potentially misleading and overly optimistic outlook. Another incorrect approach is to simply state that the market is in an expansionary phase, and therefore property values will continue to rise indefinitely without any quantitative analysis or consideration of historical trends. This is a failure to provide competent service. It lacks the necessary analytical rigor and relies on anecdotal observation rather than data-driven forecasting, which is a breach of professional standards and the licensee's obligation to provide accurate and informed advice. A further incorrect approach is to use a complex, unverified predictive model that has not been validated or is based on speculative assumptions about future economic conditions, without clearly disclosing these assumptions and their potential impact. This is ethically problematic as it presents potentially unreliable information as fact, failing to uphold the duty of honesty and integrity. Professional reasoning. Professionals should adopt a systematic approach to risk assessment in real estate cycles. This involves 1. Data gathering. Collect historical sales data for comparable properties and relevant market indicators in British Columbia. 2. Historical analysis. Calculate average appreciation rates over significant historical periods, accounting for different market cycles. 3. Cycle identification. Analyze current market indicators, e.g., inventory levels, sales volume, interest rates, economic forecasts, to determine the current phase of the real estate cycle. 4. Projection and adjustment. Project future appreciation based on historical averages, adjusting for the identified current cycle phase and clearly stating any assumptions made. 5. Client communication. Present findings clearly to the client, explaining the methodology, potential risks, and limitations of any projections. This structured process ensures that advice is well-founded, transparent, and aligned with professional obligations.